Good afternoon, ladies and gentlemen, and welcome to this webinar on how the latest adequacy decision affects your data flow mapping. I'm Alan Calder. I'm the founder of IT Governance. I'm the author of a number of books on cybersecurity and GDPR, and we as a company have been involved in the world of privacy for a number of years. Excuse me while my slides confuse us. We've been involved in the world of cybersecurity and privacy for a number of years. We set up the very first set of practitioner and foundation training courses for GDPR, just as it became the thing that organizations had to do. And we've had some 15 years helping clients tackle privacy, data protection, and cybersecurity. Generally speaking, from a governance and risk management perspective, we have a lot of clients across 6 odd continents, penetration testing amongst the many services that we deliver to our clients. With me is Gary Baxter, who's going to introduce himself right now.
Good afternoon, everybody. Yes, as Adam was just mentioning, my name's Gary Baxter. I've been with the group for just over 4 years now, and I form part of the Senior Technical Sales and Support division of Vigilance Software, and I will slot in at some point later in the presentation today to illustrate how our software tools can assist you in data mapping exercises as you go through. Thank you, Adam.
Vigilance Software is a software subsidiary inside the group. Its core tool is CyberComply. It's a tool which is designed to make compliance easy for organizations across data protection and cybersecurity, where being able to demonstrate compliance and sustain that compliance over an extended period of time is critical to being effective and efficient in doing that job. Webinar today, and I'm your host, as you will have guessed, is first of all what the recent EU adequacy decision means for UK businesses, what the requirements are in terms of data mapping and how to map data flows to comply with GDPR, how the Vigilance Software data flow mapping tool can help, and practical steps and tools to support that as an exercise. There is an opportunity for questions and answers at the end. The total webinar is designed to take a maximum of an hour. So we're aiming to finish the presentation within about between 45 and 55 minutes, and then there's a period of time during which you can ask questions. You can use the chat function that will be sitting at the top of your screen. You can also use the question function to put in questions, and we'll pick them up and share the questions with everybody, and then obviously answer them. So, what the adequacy decision means for UK businesses, and what do we mean by an adequacy decision? On the 28th of June, the European Commission announced that it had decided that the UK's data protection regime post-Brexit met the EU's requirements in terms of providing appropriate levels of protection for data subjects. And that's hardly surprising, given that right up until the end of December 2020, the UK's data protection regime had been part of the European Union, and there'd been almost no divergence between the two systems in the 6 months following. So the European Union was looking not just at the current state of play, but was trying to take a guess as to how things might evolve in the longer run. But the key point about adequacy is that it means that the European Union, the European Commission, has decided that for the purposes of data flow, data can move between the European Union and the UK without the need for organizations to put in place any other contractual mechanisms or safeguards that might be necessary to deal with the flow of data from the EU to what's called a third country. When you see that in the overall perspective, the timeline from 2020, back in July 2020, what's called the Schrems II decision, that's a result of an action brought by Max Schrems, who leads a not-for-profit organization called None of Your Business. NOIB brought an action saying that the EU-US Privacy Shield was illegal because it didn't guarantee the same level of protection to European data subjects from America as those subjects would get in the European Union. And the Criminal Justice Court of the EU, the Civil Justice Court of the EU, decided that the Privacy Shield was invalid, and as a result, it has been not possible to move data between the European Union and America without putting in place alternative mechanisms for keeping data flowing after Brexit. Of course, the invalidation of the Privacy Shield created a concern around the flow of data from the European Union to the UK, particularly given that the CJEU had ruled that the UK's Regulation of Investory Powers Act was unlawful. That was a decision in October 2020, and that is effectively saying that there are government mechanisms in the UK which mean that the level of protection for UK data subjects is not the same as it is in the European Union. The European Data Protection Board, the EDPB, following the Schrems II decision, issued new standard contract clauses for consultation in November and new guidance at the same time on international transfers, essentially saying that while organizations could transfer data to the United States, given the possibility of US government interception of that data, if it's being processed in the States, any controller transferring data would have to ensure that not only were there standard contract clauses in place, but that there were additional safeguards which would make it impossible for the US government to access that data. The UK left the EU on the 31st of December, and from the 1st of January, UK GDPR replaced EU GDPR for UK organizations. And UK GDPR is essentially EU GDPR with a couple of minor changes, for instance, saying that the scope of the Act is UK organizations, not EU organizations, saying that the DCMS is the entity that makes decisions about how the Act should evolve, not the European Commission, but essentially it was the same law just applied in the UK. So UK GDPR is the ruling system in the UK with effect from January 2021. And the adequacy decision which the European Commission arrived at essentially says that in spite of worrying about RIPA, we've decided that the UK rules are essentially equivalent to those in the European Union. The data subjects get essentially the same level of protection in the UK as they do in the European Union. The Information Commissioner is considered to be an effective supervisory authority. So says the EC, we can rely on the ICO to enforce the UK GDPR, and so there are no practical changes required to data flows between the UK and the EU, or between the EU and the UK. I say between the UK and the EU because the UK did, prior to Brexit, decide that it would recognize all of the European Economic Area, which includes the EU and those other countries which the EU had recognized as having adequate data protection regimes. The UK had decided would roll those over and would recognize them as being adequate. So that means that from an EU perspective, data can flow to the UK. From a UK perspective, data can flow to the European Union and also to all the other jurisdictions that the European Commission had previously decided would be adequate. After the 1st of January, the UK has to make those decisions completely for itself. It's no longer going to be automatically deciding that whatever the EU thinks is what the UK thinks. So with effect from the 1st of January, EU GDPR applies across the 27 member states of the European Union, and UK GDPR applies to all organizations based in the UK or to organizations outside the UK providing services into the UK. And the EU adequacy decision covers only data flows from the EU to the UK. It doesn't cover any other data flows at all. It's only EU to UK data flows. So it's quite possible that a UK organization may find itself having to comply with two data protection regimes simultaneously. The first is the UK GDPR, which is in force through the Data Protection Act 2018 if you process UK domestic personal data, and if you're also providing services into the European Union, then you probably have to, not probably, then you definitely have to comply with EU GDPR as well. At this point, that's relatively simple. The duality is quite straightforward to achieve because the laws are essentially the same, but as time passes and the laws diverge, so that dual compliance will become harder. If you're providing services into the EU, what else do you have to do? Well, you have to appoint an EU representative in just the same way as an EU organization providing services into the UK has to appoint a UK representative. So in other words, adequacy does not absolve you of appointing a representative in the EU or in the UK, depending on which way you're providing services. If you're providing services into the European Union, you have to identify a lead supervisory authority in the EU. With effect from the 1st of January, the Information Commissioner ceased to be an EU ICO, so could no longer act as a lead supervisory authority for organizations providing services into the European Union. So you've got the ICO in the UK, and if you're providing service in the EU, you choose which supervisory authority you want in the EU. Probably the same country in which you've appointed an EU representative from a point of view of practicality. And then you need to update your policies and procedures and any other documentation to reflect the dual compliance requirements that you have. How do you know whether or not you need to, how do you decide whether or not you need to appoint an EU representative? Well, it comes down very simply to whether or not you're providing services into the European Union. If you are, then you appoint a representative in the EU who will represent it with respect to your GDPR obligations. It serves as a local point of contact for data subjects and the supervisory authority, and it holds a record of the organization's processing activities. It is not responsible for GDPR compliance. And you can appoint an organization in the UK, for instance, who has a EU partner, as long as your appointed representative is based in the European Union and is able to act as your representative. The EU and UK supervisory authorities, they're essentially the same at this point. Again, there may be divergence, but at the moment in the UK, it's the Information Commissioner. In the European Union, every other member state has at least one supervisory authority. In Germany, for instance, there's one for each of the federal states. And the role of the supervisory authority is to monitor and enforce compliance with GDPR, receive complaints from data subjects and other bodies, provide guidance and promote awareness, and cooperate with other supervisory authorities. That's cooperation, collaborative regime is obviously appropriate inside the European Union, where it is part of the requirements of the GDPR. It's because the UK is outside of it. It's no longer a requirement on the ICO, although practically and pragmatically, the ICO will tend to work with other supervisory authorities in the interests of making data protection effective for those organizations that fall within its scope. So, given adequacy, given the fact that it applies only to those jurisdictions for which an adequacy decision has been made, let's step back a bit. What are the basic requirements in terms of data transfer? What GDPR says is that any processing of personal data that involves the data being processed outside of the UK or outside of the European Union, we'll focus on the UK for the minute, has to be carried out in a country that falls within the data transfer rules. The transfer is restricted. If you're sending personal data or making it accessible to a receiver to which GDPR does not apply, which is recipients located outside the country in what's called a third country, or you're making transfers within a large international organization, parts of which are based outside the UK or outside the EU as the case may be, but are all under the control of a central authority inside the EU. In each of those cases, it is necessary to look at GDPR to identify what the basis is on which you can transfer data. Remembering the very broad definition of processing where GDPR is concerned. Processing isn't simply the storage of data or the manipulation of data. It includes somebody being able to access data from within a third country. So being able to read data from within the US is part of the definition of processing within the US. Your options for data transfers to third countries are an adequacy decision. We've talked about those. Safe harbor or privacy shield, where the US was concerned. Both of those have been struck down. And while the European Union and the US are apparently in discussion about a replacement for privacy shield, it's not clear what that might look like. And then there are SCC, standard contractual clauses, and binding corporate rules, or BCRs. Standard contractual clauses are the most common form of legal control, and they are a set of clauses written to be deployed almost exactly as written, but to apply specific legal obligations on the recipient of personal data. What the recipient can't do is stop a government in its own jurisdiction from intercepting that data, which is why there are circumstances under which standard contract clauses might not be adequate. There are occasional transfers, so you might be transferring data to a hotel in a third country, and there are a set of possible options that you might be able to put in place to deal with what you might call occasional transfers, not consistent, regular transfers as part of ordinary business. And in most cases, those which are dealt with in Article 49 of GDPR are going to be inappropriate for organizations. So what you're looking at are standard contract clauses, and unless you are an international organization, in which case binding corporate rules might be an alternative. But the problem with binding corporate rules is they have to be written for each organization specifically. They're not templated. They have to be signed off by a supervisory authority, and they're therefore difficult to change. And given the speed with which cybersecurity and data privacy requirements change, having some flexibility around how you deal with them makes more sense. And standard contractual clauses is a route to doing that. So under UK GDPR, the government, as I said, it is recognizing all of those jurisdictions that had previously been recognized as adequate by the European Commission, and it's confirmed that. And DCMS today said that it's assessing a number of other countries, Australia, Colombia, Dubai, India, Indonesia, Korea, Singapore, and the US, in respect of the possibility of whether or not their data protection regimes are adequate. Whether this is a genuine exercise or a cosmetic one remains to be seen. Of course, if, for instance, the UK were to decide that the US has an adequate data protection regime, that would, from an EU perspective, open the possibility for data being transferred to the EU, from the EU to the UK, and then on to the US, which the EU itself doesn't allow. So that could call into question the adequacy decision given by the European Commission in respect of the UK. And the European Commission is very clear, and always has been, that an adequacy decision can be withdrawn as quickly and as easily as it is granted. And this is important because the potential penalties for non-compliance in the UK are up to £17 million or 4% of global turnover, whichever is greater. And you can find yourself, as organizations did when the Privacy Shield was invalidated, of operating what appeared to be a legal transfer of data one day, and then it was illegal the next day. So you had to scramble to put in place a process that was legal. So the EU adequacy decision means a lot for organizations who are transferring data between the UK and the EU, but it doesn't mean very much for organizations transferring data between the UK and the US or other third countries. The status for the UK today is that data can continue flowing between the EU and the UK without further controls, but organizations, US organizations providing services into the UK or the EU will need to appoint a representative in both jurisdictions, as well as a separate lead supervisor authority in each jurisdiction. And any organization in the UK or in the EU transferring data to the US will need standard contract clauses plus additional controls, in other words, an individual risk assessment, in order to ensure that the data is not going to be capable of being accessed by the US government. This is a fast-changing area. Both the UK and the European Commission are, I know, looking at ways to try and ease the circumstances, but at the same time, NOIB, Max Schrem's organization, is bringing further actions to seek legal decisions that data transfers, which are still taking place outside of standard contract clauses with additional controls, are illegal. So it's an area in which, as an organization, you have to be very clear on the risks that you take when you transfer data, and in particular when you use software that might be implemented as part of an application, but where the processing of data inside that software, like an emailing system or a CRM system, for instance, and the data is actually processed in the US. Data sovereignty will become quite a big issue for organizations in this evolving circumstance. So that raises the challenge of, where is your data? If you're a UK organization and you're processing data, do you know where your data is being processed? If you're outsourcing processing to a supplier, do you know where they are processing the data? So you need, if you're going to comply with GDPR, because as the data controller, you are responsible for, you're on the hook for the processing of data, irrespective of how many organizations you sign up or they sign up to process data. You're the controller. You have to make sure that data is being processed in line with GDPR. That means the software you're using, the third parties you contract with, they have to be in compliance with GDPR. And you tackle that by, first of all, looking at, of course, am I compliant with the UK GDPR? That's an important step to put in place. You do a detailed gap analysis. You look at a GDPR compliance checklist, but critically, you do a personal information, personal data inventory, and you map the data flows. You identify what types of personal data you've got, and you map the data flows all the way through from where it comes into your control to where you destroy the data because it's reached the end of the period for which you're legally keeping it, or because it now passes out of your control, and you ensure that through all of those data flows, the data flow is in compliance with GDPR requirements. And you can really only do that if you map the data flow in some detail. That means you need to map all of the different people who are going to see the data. It might all be in the same place, but different people are accessing it. It might be moved around inside a system. It might be stored in different places. You might have copies of it stored in different places, but you need to be clear about where all of those elements are. If you ever have a data breach, one of the first things the Information Commission is going to want to ask you is, where is the data? How has it been moved? Have you made sure that the attackers have not been able to access that data anywhere else inside your network? And in order to meet the requirement of Article 30 of GDPR, which says you have to carry out a data inventory and determine where it's stored, you have to create a data flow map, a detailed mapping that, as I said, identifies what the assets are, where it is, who has access to it, how does it move, and so on. And in the process of that, you can begin thinking about how you secure data effectively. You can think about how you secure data when it's being transferred. How secure is it when it's being accessed on a mobile device, being accessed in the cloud, being sent to a third party as part of an outsourced service, or when a device itself is sent to a service provider for reconfiguration. All of those are areas where data might be exposed to somebody who doesn't contractually or legally have a right to see it. So mapping tells you that, it enables you to work out how to secure it. And it means you can look at options like encryption or privacy enhancing technology to secure data while it's in your control, and even possibly to anonymize data. When you anonymize data, you effectively remove from it any elements that enable an individual to be identified, and that puts the data outside the scope of GDPR and means that it can be moved without further security. So mapping data enables you to put in place appropriate data security mechanisms. And to do that, you've either got to have a big wall with lots and lots of pieces of post-it note that you can move around in order to try and map the data flows, or you need some intelligent mechanism for doing it. I'm going to hand you back to Gary Baxter now, who's going to talk to you briefly about our the Vigilance Software data flow mapping tool, and is then going to give you a demonstration of how you can use that tool to map data. So Gary, over to you.
Excellent, thank you very much, Alan. So yes, as Alan has just mentioned, I'll be taking over the next 10 to 15 minutes of the session, and in which we're going to highlight the importance of, obviously just to echo what was mentioned a moment ago with regards to highlighting how your data is being secured, so that if you are put on the spot all of a sudden by an authority, that you can very quickly and easily explain both, yes, we know exactly where our data is, we know how it's handled, we know what security we have in place should something go wrong, and we also have some form of fallback just in case there is a breach at any point. The purpose of CyberComply being created for that, and with inside of it data flow mapping, is it gives you the ability to very quickly illustrate to both internal stakeholders, external stakeholders, and authorities that not only have you not just shown the data flow map itself, you're also identifying extra levels of detail, such as you've done an asset inventory, so you know exactly where data is being stored, not just the data itself. You're also able to highlight areas such as, do you have encryption? Do you have some form of mechanisms in place to ensure that the data in the transfer itself, not just in storage, is going to be kept secure at all times? And there's a number of other entities in which you can link to, such as if you have policies, there may be documentation that helps support that. You can then link that to the documents and also give that extra level of detail as well. So I'm going to start sharing my screen with you now so we can give this a little bit more of a visual representation. So Alan, I believe you might need to stop sharing so that I can start sharing. So you could hand over the reins, that would be much appreciated. Okay, it appears I can't share with the webinar at the moment. Here we go. There we go. Okay, that should be coming through to your screens in just a moment, if you can confirm once it's live. Alan, is that visible to yourself? Excellent, I'll take the thumbs up as a yes then. Okay, so what we're going to cover off over the next 5 to 10 moments is just a brief overview of what the data flow mapping tool is able to do inside of CyberComply. Just again, just touching on some of the points that Alan's mentioned, it's not just about knowing what data you have, it's also about going that extra level of detail of asset inventory. It's also identifying if there's areas of concern, such as if there is a change in regulation, such as the UK suddenly having its EC adequacy decision made, the EU-US Privacy Shield dropping out, etc. And it's something that CyberComply is able to handle for you in an automated fashion. What we're looking at on the screen at the moment is ultimately a dashboard of my organization. Obviously, this is a demonstration account, but what we're able to see straight away off the bat is once you've got processes in place, you can very quickly illustrate, okay, looking at the icons on the map here, we can see, okay, we've got a set amount of information predominantly located in the UK and Northern Ireland. We've got a couple in the Bahamas, and we've also got some in Southern Ireland as well. We can also drop it down into multiple group areas. So if you need to just very quickly highlight, if you're looking at sales processes, or if you're looking at marketing or human resource, you can pull that into prominence on the view here. As we continue through, we're going to go into where the process section is created here. So this is obviously where you're going to be identifying the groups in which the process maps or the data flows are going to reside within. The examples I have are on the left-hand side. So we're looking at things like corporate processes, sales processes, anything down to logistics, so warehouse processing, human resources, marketing. Obviously, it's entirely up to yourselves how you break this up. What we're able to see once a process has been created is a quick overview of the process ownership and scope. Now, how we get to all of this is something the system can walk you through. So it's not as though you're going into this blind. It's something that can aid you in, maybe there's been a change in wording, so it's going to highlight that to you. In this case, we're going to look at one that we've created previously. So we're looking at just a very basic client capture process here. So we obtain information from existing clients. It's then going to be processed through our organization. We predominantly use that for either a marketing campaign or whether it's going to be used for sales activity in the future. What this will ask you is things like the scope of the process, so processing data of our new clients. We then have the purpose, it's engagement of new clients for delivery of our services. And then because we as an organization are certified against 27001, it's very simple for us to say, yes, we are just putting in 27001 controls to ensure the transfer of data and security of that information is kept the highest priority in the business. As we come further down, we're then able to outline what we see ourselves as in the overall process. At the moment, we're marking ourselves as a controller, and the tool itself has an area in the back end which enables you to enter in things like your contact details, your data protection officer's information, and any representative information. So it's already starting to compile that final report that, should you be put on the spot, you can provide to an auditor. Once we start looking at the process, we can then start giving some extra context to it. So at this point, we're saying that we are 27001. So we can highlight here very quickly, okay, these are the specific controls that we use. We are considering these legal requirements. It may be that a contract is in place, which is the reason for this process existing. And we have a number of other links we can set up, such as tasks for continual reviews of this particular process. So maybe it's quarterly, 6 months, yearly. We then also have areas to show the number of records that we're storing, so personal identifiable information, the number of risks that have been identified, maybe that's part of the DPIA that you've worked through alongside this process, and as I mentioned, if you've got any supporting documentation as well. Once the process is in place, you then start getting into the nitty-gritty, and that's obviously mapping out what the process looks like from an organization standpoint. So what you'll see on your screen at the moment is it's a relatively simple process. We have 3 data items coming through from our data subject. It then goes through our company website and hits our CRM system. From there, you'll start to see it starts to spider away from there. So it's going to people like our information teams. It's hitting our inside advisors' mobile devices, and then it hits things like the marketing teams, etc. What we can do with all of this information is we can, again, on the left-hand side, create those asset inventories. So these could be areas that information is going to be stored upon. It could be people within the business that information is going to be handed to, etc. We can also highlight from an asset perspective, are they a controller in the process, or are they simply a processor, joint processor, or a third party? Once the makeup of the process has been made, so we can see here that I've completed mine, we show where it's going through our organization, we can then start to show the data itself. So where is it coming from? Is it from a data subject? Is it from a broker? Is it from a third party? We can reference that information. We can create PII records. So the data subjects themselves, are they inquiries along with their personal data items? If there's sensitive information involved, what's the lawful basis behind it, and any exceptions you may need to be considering. Now that's all good and well looking at the data itself, but we also need to go the extra level with regards to what safeguards do we have in place and what things do we need to consider whilst transferring information. Firstly, highlight how the data is moved. Is it via email? Is it via hand-to-hand? Is it private networks? We can then illustrate straight away, okay, is the data encrypted? It's going through a company website. Most of the time there's a HTTPS protocol in place, so we can highlight that straight away. And when we're looking at things like cloud backups, company email servers, there might be additional encryption arrests, so on and so forth. Once we start showing the information moving through, and let's say we were to look at our company email server, expanding on this will then give you the ability to outline the types of the assets, again, the operator, where is it located, classifications, categories, and so on. We can then also show here that, okay, the record itself has a total retention period within the business of 7 years, but the known storage on this area is only actually 6 months. After that point, it no longer needs to be accessed from this particular area, and it either gets scrubbed or it's anonymized, whatever the case. Once we've gone through all of this, there may be some areas of concern, and this is something the tool will be able to identify for you. So what I've forced on here is all of my the majority of my assets are located in the UK or an EEA state. So therefore, all of those transfers, as mentioned by Alan, are absolutely fine to continue. If, however, it's going to, let's say, the US, for example, I believe we've set our cloud backup to be located in that area. So it's going to bring up an area of concern. So that's highlighted in the red lines with the exclamation points. What the tool will also do is, let's say, for example, well, not an example, something we can draw on. At the beginning of the year, the UK initially was actually set to third country, and we had the same sort of status as what I'm illustrating on the screen here. What the tool would have identified is, hang on, that transfer used to be fine, it's not anymore, and you'd have been presented with a large pop-up screen when you first log on saying you need to address these processes, you access them and make the relevant changes. So you're already starting to work in line with the new regulation without having to read into it into too much detail. If we look at the actual transfers, it gives us that extra level then to say, okay, there is an area of concern here. Now, do we have the appropriate safeguards in place? And if so, what are they? Are they binding corporate rules? We might also be able to mark out if there's derogations that may apply. That could be public interest, transfer from public register, etc. Once the work has been completed in here, you'll then have your final reports. Now, the reports are very quickly ran and they pull all of the information I've shown you so far into one neat and easy to read area. We have the overall controller's contact details, so that's us in my case. We then have a process overview, so highlighting all of the technical and organizational security measures. There's summaries of the information that we're handling. We then have an overview of the process map to give a visual representation of what's going on, a list of the personal data inventories. We have a list of the data subjects and their location as well. The asset register, not only just what the name of the asset is, all of the records are stored on it, its classification, the locations, and if there's any encryption. And then the final stage on here is something that's obviously very key. It's the transfers themselves. So how is information moved? Where is it coming from? What information is actually involved? And if there's any sort of encryption or any security measures you put into place to do that. Once that's been put in, like I mentioned, you can just leave it to sit there. If it's a process that doesn't update very often, it's absolutely fine. However, our system's intuitive enough to understand that if there is a large regulatory change, it will flag this automatically for you and say, hang on, these now need to be addressed. And that could also cause things like your DPIAs that match that process to fall out of, excuse the word, whack as well. So therefore, it will then encourage you to go through and reassess maybe a certain privacy risk that you'd identified before that may need some additional controls put into place. But that is CyberComply and the data map. And obviously, I appreciate it's a very short session. I get to illustrate the tool, but obviously, if you'd like to know more, please feel free to pop it into the chat box. And we do also offer free trials if you want to get your hands dirty on it as well and see what it can do for your organization. So I will stop sharing my screen with you now. Just going to, again, figure out how I do that from my side. Okay, I think Alan's taken over control. So that's everything for myself. There's a couple of other slides that I can go through as well, or I can hand back to Alan. But ultimately, the purpose of CyberComply and the data mapping tool is to make it very quick and simple for organizations to quickly highlight assets they have involved, levels of security that need to be concerned, any jurisdiction or regulation change, and the very ease of use of actually mapping out that process and showing the data flow in its entirety.
Great. Thank you, Gary. Let me get my slides back up. Working as quickly as we would like it to. Okay, hopefully that is now sharing. So, in the assumption that you can see the slides again, folks, the benefits of CyberComply is that it's a platform which is designed to make your life easy in terms of complying with both UK and EU GDPR. It integrates with a cybersecurity module so that you can map data, but you can also link that mapping to control frameworks, whether from ISO 27001, 27701, in fact, pretty well any control framework in the world that's relevant to information security management, so that you can demonstrate how a specific set of controls are deployed to meet the requirements of GDPR. So data flow maps, links to data protection impact assessment tool, links to the compliance manager, which has all of the up-to-date data around GDPR, so that everything that you might need to know will turn up. As Gary says, you could log onto the machine, log onto the application, and you will find a couple of tabs saying the law has changed, you need to review these areas of data flow for you. So that from an organizational point of view, you can be sure that you're going to stay compliant without needing to spend a lot of time and effort keeping track of what compliance requires. And that means that not only are you staying compliant, but you're reducing data security risks. And knowing where your data is means that you can ensure that you've got the data processing risks identified, and you've put appropriate controls in place. You've identified what steps different individuals have to take to carry out and enforce those controls, and you can handle anything that's going to access data efficiently. If you think about doing a data subject access request, you're legally required to generate all of the data that you're holding about an individual. A data flow map tells you where that data is and who has it, so that you can pull it all and provide it. It enables you to organize third-party data flow audits to make sure that they're complying with your contractual requirements about how they're managing data that they're processing for you. So data flow mapping is at the heart of effective GDPR compliance. And if you go on to the Vigilant Software website, you'll be able to find out a lot more information about CyberComply as a tool. You'll also be able to see pricing. You'll be able to see how the different elements fit together. And you can, of course, if you're buying through IT governance, you can access the same product and service through IT governance. But Vigilant Software is the core business that provides all of that. Across the IT governance group, there is a range of supporting products that can help you tackle GDPR and cybersecurity. So you can, through GRCI Law, which is our in-house law service, access an IT governance EU representative service. You can get data protection officer as a service. We can help you put together appropriate data transfer assessment and action plans that will enable you to comply with the requirements of GDPR through DQM, which is our privacy by design business, and through GRCI Law. We can assess overall compliance with GDPR. We've got a broad range of GDPR training courses, both foundation, practitioner, and DPO formal qualification. So a comprehensive package of products and services designed to work together to enable you to achieve GDPR compliance consistently and broadly trouble-free. And for most organizations, GDPR compliance isn't something that you want to be front and center of what you do. You want it in the background. You want to know that it's safe and secure, the job's done, and you can concentrate on what your business is about without needing to worry about a big gaping hole in GDPR compliance in the background. So it's pretty well it in terms of what the adequacy decision means, how that flows through in terms of how you can move data and the areas where you have to be paying special attention to dealing with data flow issues. There is a series of monthly flash briefings. They are short 15-minute briefings that focus on a key topical subject. You can register for them through this link. The links in the slides. We'll be circulating the slides together with the recording following the webinar. But folks, that's all we have planned to say today. So a number of ways you can contact us, a number of ways you can follow up. And this is the time when, if you have a question, please do feel free to ask it. The way to do it is to simply go into the chat area, type a question in there. Yes, so somebody had technical issues. We'll be able to share the recording shortly after the webinar. Do in the chat function, you can get it by pulling down on the box above your screen. If you're in full screen mode, there's a little icon there for chat. You can type any questions you've got in there and we'll pick up the question and answer it. Do we think that the changes announced today are a sign of more changes to come? So the key changes that we understood that were announced today were that the DCMS is assessing a number of countries for adequacy. It's published its adequacy tests and set out how it's going to go about doing that, but that doesn't mean it has made an adequacy decision, and that's a really important thing to bear in mind. Right up until the moment there is an adequacy decision, if there is one, you have to work on the basis that there is not. The reason that there is not is particularly relevant in terms of the US, and there are a couple of questions about that, so let me pick them up. What does additional controls mean when transferring data to the US? And that's particularly difficult. The European Data Protection Board has published guidance on EU to US data transfers, and essentially it means making sure that the US government through the National Security Authority or the FBI cannot access the data which is in the US. And that's kind of hard to do. You have to make the risk assessment yourself. You have to document the risk assessment. You have to document the controls you put in place. You have to determine whether or not you think it's a risk. And then you have to put controls in place that will protect you from that. And that's not easy to do. Typically, the only way you can do that is with encryption, and encryption that a US entity can't get through means retaining the encryption key in the European Union or in the UK. And that means that the data is useless in the US if you want someone to be able to access it there. So in practical terms, our experience at the moment is for most organizations, it becomes very immediately a question of data sovereignty. Does my supplier have a mechanism for hosting data in the European Union or in the UK? In which case, please can you host it there? And that saves me the problem of having to try and work out how I can get secure. The reality is that many organizations have not yet complied with Schrems 2. It's difficult to see how you can and stay, if you're a large organization and you say you're complying with Schrems 2, but you're still processing data in the US relying on standard contract clauses plus additional controls, I would imagine that sooner or later NOIB is going to be bringing in action. So I'm sorry, I don't think there is at the moment a secure way to transfer data or process data in the US using standard contract clauses. Do you still need to appoint an EU representative if you're based within the UK but have locations within the EU country? Well, that's a kind of matter of fact. You could appoint, if you're a UK organization providing services from the UK into the EU, you will have to appoint an EU representative. There's nothing to stop you appointing your own EU subsidiary as your representative, but you will need to have a representative in the EU. The EU GDPR says the representative, and it doesn't describe what the organization has to be based in the EU. So yes, you must do. SCCs, in terms of SCC for use of transfers with the US, can any SCC be effective in preventing the vested powers of the US government? No, it cannot be, and that's why the Privacy Shield collapsed. The US government has the power to require the handing over of any data if it thinks it's necessary in pursuit of criminals or terrorists, and from the EU perspective, that means that EU residents do not have the same level of legal protection of their personal data in the US as they do in the EU. And that's why the Privacy Shield fell over. And that's why, in my opinion, it's highly unlikely that there will be a replacement for it, because I can't imagine that either the US is going to give up that legal right, or that, and this is another key issue, it is going to put in place a countrywide data protection law. At the moment, the US has no single data protection law that covers all 50 member states of the US. There are 50 separate sets of data protection laws. Many states don't have much in the way of data protection laws. All states have breach reporting laws, and that's a practical mechanism that isn't there to enable the US to be recognized as adequate. So how the UK could hope to recognize the US as adequate in the current circumstances, I cannot imagine. We're working and we're advising clients to work on the basis that nothing is likely to happen anytime soon. Is the software one size fits all, or is it price scalable depending on the size of the company that needs it? Yes, it's price scalable based simply on the number of users. So large organization with lots of users, because you've got lots of data and departments and so on, it's based per user, so you'll pay more than a small organization who only needs up to 3 users. Should UK organizations look for other options than Google Analytics? Yes, I'm afraid so. Google is still processing data in the US and says that it's relying on standard contract clauses to do that. Google is in receipt of an action from none of your business at the moment, as we understand it, because from Max Schrem's point of view, they are still in breach of the EU GDPR. So I hope that run through of questions. I hope I've picked up your question if you asked it. If there are any more questions, please do stick them into the chat function. We've got a couple more minutes left if you want to take advantage of them. So in that case, folks, I'd like to thank you all for joining us. I hope you found the webinar useful. As Gary said, we'll circulate the slides and recording later. Sorry, another question. Would it be an issue to complete cloud backup with GDPR compliance? It could do. It depends entirely on where the hosting is concerned. Most of the large hosting organizations will be able to meet data nationalization requirements. They'll be able to offer you hosting in Germany or in the EU or in the UK. You should select those hosting options and then you're able to meet the requirements to host data in a jurisdiction for which there is an adequacy decision. So folks, I hope it's useful. Please do take a closer look at our CyberComply data flow mapping tool. There is a free 1-month trial version available. You do have to put your payment details in advance to access it, but it's available and it's a whole month that you can use for free. Get used to it, and if you're happy with it, then of course you just simply continue. If not, then you decide to cancel. But you know, it's a very straightforward, practical way of consistently meeting your GDPR compliance requirements in this rapidly changing environment. Thank you all for joining us. Please do have a good rest of today and stay safe and well. Bye-bye.